Hello everybody, and thank you very much for joining this webinar with Hmcts. And as you can see, we've got a very large and distinguished panel of experts to help us with all of the questions that you have about what's going on in the way the courts are run. Before we begin, I know you will have had instructions about how to operate on a Zoom call, and I expect many of you are very, very familiar with it. But just to say this session will be recorded and made available through the Bar Council website after the event. And as a participant, your name and any questions or chat that you submit during the webinar may be shown on the recording. So if you object, best not hang around. But I hope you do hang around. Because we've got a really great panel today of people who can answer all the questions that you wish you didn't have, but you do have about what's going on, particularly in the light of COVID-19, but in our courts and tribunals. And may I just very quickly introduce everybody. Susan Ackland Hood has been the Chief Executive of Hmcts since November of 2016, so it's been easier and easier as her time's gone on. And she's responsible for the overall leadership, delivery of services, strategy and vision, as well as the accounting officer for the organisation. And she and I would say anyway, have had a very positive and open lines of communication over the time that I have been chair and indeed vice chair of the bar. We've also got Claire Dukes, who's the person who knows everything there is to know about CVP, service delivery, and she also is in charge, which I think is rather marvellous, of continuous improvement. So I expect she's pretty busy. Helen Measures is the crime service owner responsible for the administration of criminal justice in England and Wales, and she has been hugely involved in restarting jury trials, and in fact I'd say that's how I've got to know Helen. But before COVID I think she was also dealing a lot with magistrates courts, but I think enough was enough, and I think somebody else might have more control over that now at this moment. We've got Claire Barrett, who's the interim property director. Her areas of expertise include estate matters and property strategy, including what they are calling additional court and tribunals capacity programme, and I think we might know more as Nightingale Courts or Blackstone or Bingham, but now back to Nightingale. Jason is Deputy Director who leads for Hmcts on extended operating hours, so he's your favourite person on this panel. And he is leading the development in relation to courts and tribunals as well. And he has got a lot of experience of tribunals, both here and in Scotland. So if you've got questions about tribunals, they're almost certainly going to go to him. Simon Voles is Deputy Director for Civil, and he has been in post since January this year. So he's a bit like me. He was thinking it was all going swimmingly, and then something happened. Before that, he was Head of Civil, Family and Tribunals for the North West, and he's worked in the courts for 30 years. Gemma is, I won't say she's in charge of everything, but that's how it feels when Susan's not around. And I know that we're going to be hearing also from Anne-Marie, who is going to deal with CVP as well. So thank you all very much. I think I've covered everybody. If I've missed anybody out, please forgive me. But we will definitely come to you in a minute. What I did want to say before handing over to Susan, just to say a few words of her own, is I think Susan's blogs on the Gov.uk website over the last year really tell you the story of what has been going on. Because in August of last year, her blog was selling off the silver or ensuring we're fit for the future. The next one, there was a bit of a gap, was the 8th of April of this year, responding coronavirus in our courts and tribunals. a few days later, on the 30th of April, using remote hearings to maintain justice during the coronavirus pandemic. Beginning of July, coronavirus recovering in our courts and tribunals, and now, 9th of July, recovery in the Crown Court. And so I think what we've got there is a real whistle-stop tour through what's been happening this year. And I hope very much that many, many questions that have already been asked will be answered. But before we get on to them, Susan, over to you for your overview.
Thanks very much indeed, Amanda, and thank you everyone for having us. I'm just going to do a very brief overview. I'm not going to speak for very long because I know that what we're really here for is to answer questions. But I thought it'd be worth just talking a little bit about where we are in Hmcts and particularly the COVID response. So one of the things Amanda suggested I say, and I'm sorry if I'm teaching people to suck eggs, is just something really brief about Hmcts and how it works. So Hmcts is responsible for the administration of the courts and tribunals in England and Wales, and for the tribunals on reserved matters in Scotland and Northern Ireland. And we're a bit of an odd beast in the sense that we operate underneath and facing both the executive and the judiciary. So I report through an independently chaired board jointly to the Lord Chancellor and to the Lord Chief Justice. And part of my job is to make sure that I'm serving the independent judiciary extremely well and providing everything that we can for the operation of the court, but also that we're doing that in a way that is in accordance with the asks of the government of the day. And various of my predecessors have likened this to sitting on a two-legged stool. It sometimes takes a bit of balancing. I wrote something early on that said, on a good day, it was more like lying in a hammock that was anchored at two ends. You've got a bit more freedom than in a normal setup, but you do need to know that both of your two posts are well anchored and that they have a good relationship with each other and aren't about to kind of depart from one another. What we do covers, as I say, the administration of the court. It does cover buildings and all of those things, but we also work really closely with the judiciary. Our framework document with the judiciary says we all work together to find ways of making the court system work more efficiently, more effectively, and do things better. And so that's the kind of framing context for everything that I'm going to say. In terms of the year that's just gone, I think it's probably a right starting point to say that we came into the coronavirus crisis already with some challenges on our hands. People will be most familiar with where we are, I think, in the criminal court. We're in a reasonable position in the Magistrates court, but in the Crown Court, we'd had a year where we'd been allocated fewer sitting days than the amount of work that then started to come into it. So we went from a position of having, we were actually in an incredibly good position in March 2019. We had one of the lowest levels of outstanding work in the Crown Court that we'd ever seen, and we had very low waiting times as well. Once you looked at what was happening, once cases came into the court system. But that position had worsened over the course of 2019 to 20. And we also had quite long-standing challenges in the family court where significant increases in volumes hadn't been matched as quickly by increases in judges to hear the work. And so we came into the pandemic with some challenges, but also with some strengths. So a lot of the work that we've been doing on reform has helped us to manage through the crisis. And one of the things I would observe is that in those areas where we had reformed work, where we were able to work digitally, we've been able to weather the storm much better. So when we look at our performance in our reform services, actually we aren't building up backlogs in general, we're managing much better. I'm just going to talk a little bit about our COVID work and our recovery plan, and then we'll go into the questions. So I'm just going to screen share. So there'll just be a moment where I check that that's come up for people. So can I just check from somebody that you can see that?
Yeah.
Great. This is the brief document that we published in July that gives an overview of our COVID response, and it starts out by talking about the the challenge that the coronavirus has presented, particularly for a system where there are many things which need people to meet physically together, which has been more challenging than usual. It talks a bit about the first phase of our response, which was really a kind of emergency pull of the button to try and prioritise the most urgent work. So we were able to do the most urgent work in the family court, to do all our overnight remands and the other urgent work in the magistrates court absolutely throughout. We have not shut down at any point. Anybody starts talking about the courts closing, the courts did not close. We reduced the number of courts we were operating from, but our core, most essential work continued absolutely throughout. We rapidly expanded what we could do using audio and video. We started doing that in a relatively tactical way, using the systems that were immediately available to us. And I know lots of people have asked questions about that, which we'll come to later in the session. And then we continued to do as much work as possible, as I say, using reform services, online ways of working. All of our staff were designated as essential workers, as key workers, and we continued to, where people couldn't do their jobs from home, we continued to ask them to come to work to do their jobs. But we did also look at kitting our staff out to work from home where they could. And we've now issued somewhere close to 9,000 laptops to Hmcts staff during COVID-19, which has allowed us to keep more work going. And then we've implemented the practice directions and the Emergency Coronavirus Act. The second phase, which we're really still in, has been about trying to rapidly recover our operations and to do more work. So in that initial phase, we focused on the most urgent work. There were very few work types that we completely stopped, but there was a lot that happened in far lower volume than normal. And now we're in the stage where we're trying to do as much as we possibly can. So we've reopened all the courts and tribunals which had been closed to the public or had been operating as staffed courts. There are a very small number still closed. There are some tribunal venues in Scotland where the context is a bit different. And there are also a small number of buildings where there are other issues, and a couple where they are just so tiny that it's really difficult to make them work with social distancing. But basically we're all open again. We have then got 3 pillars which are described here around trying to use as much of our space and capacity as we can, because the fundamental challenge of COVID is space. We have to keep people suitably separated. We can't fill waiting rooms as we normally do. We can't fill courtrooms as we normally do. And that's meant modifying things in the existing estate to try and use as many rooms as we can. We've done 2 rounds now of assessing every room across the whole of the Hmcts estate in every jurisdiction to see which rooms can safely be used with 2 metre social distancing. And that looks not just at the room itself, but at the whole building. So if we have many rooms in use, can we manage people in the public areas of the building in a way that's safe and secure? We've now done a second round of assessment at 2 metres based on what we've learned about operating and found that we can bring more rooms back into use. So you'll start to see more rooms coming into use at 2 metres. And we've looked in that round of assessment at what we can do at 1 metre plus. In other words, if we put in other mitigations, which Public Health England tell us can safely mean people can get a bit closer to one another, which other rooms can we bring into use in our buildings? And we've got a comprehensive list of every room across the estate that says, we just don't see how this can be used, or this can be used now, or this can be used if we put these mitigations in place. And then we're working through the timescale for getting those things put in place so that we can use more and more of the space that we've got. We're also looking, as you know, at using other buildings, and the first kind of really new Nightingale Court has opened this week in Prospero House near Southwark. And we're also exploring options for using extended hours, because where the thing that is constrained is space, then that is a way of us being able to do more work in those spaces. We're not going to do that everywhere or for everything. It's for the places and the jurisdictions where the thing that is limiting our ability to hear the cases that we need to hear is the physical space available. And then the second pillar is around continuing to increase the use of audio and video technology and using them for as many of the case types that they're suitable for as we can. And again, I know you've got lots of questions about that. Continuing to roll out a cloud video platform, which takes us off some of those tactical technologies I talked about earlier onto something that's more stable and better suited to hearings. And looking at how we're organising ourselves to do that work. So we hear sometimes that using video or other means is taking longer than traditional hearings. And that may well be the case, but it may still be true that it's better to do it than not to have the hearing, or to find that we can't get ourselves operating in a particular space. But it would also be quite surprising if we had stumbled on the most efficient possible way of listing video hearings through going through the process we went through at the beginning of COVID, where we essentially turned it on as fast as we possibly could and asked people to use it out of goodwill. And so we want to do some more work on how we can make that work better, how we can improve the way that we are listing and organising ourselves when we're doing video and hybrid and other types of hearings. And then on the right-hand side, it describes some of the things that we're doing to support our staff, which I've talked about, but also to look at alternative ways of resolving disputes where that's appropriate. And it says at the bottom, we'll continue to keep under review further options which will enable more hearings to take place while social distancing restrictions remain in place. And that is things that have been raised around, might we need legislation to allow for smaller juries? Would that allow us to do more work? But also some of the options that are being tried in Scotland around remote juries, and essentially we continue to keep our minds open, working with Ministry of Justice colleagues and the judiciary and others to other options and other things that we might do. So if people have suggestions, we're more than open to them. It sets out a brief timetable for when we will do these things. It talks a little bit about the challenges in each jurisdiction. And then it talks about the third phase, which is about starting to look to the future and think about what we've learnt from going through this experience, what we might want to hold on to into the future. So there will be a huge amount of learning that comes out of this. Not everything we've done during this period is something we want to keep doing in the future. Some of them are just an emergency response, but some things we might want to learn from and take forward. And there's more information in the annex. And the one thing I would draw your attention to is this bit here that says management information, which sounds very dry, but that is where we publish our figures on the work that is being done, so that you can keep an eye on how much work is going through the courts and what we're doing. And I'm going to stop there so that there's time for questions. I hope that was at least a moderately helpful overview of the context of the work that we're doing at the moment. Thanks, Amanda.
Thanks, Susan. Thanks. Great. Well, I think what we'll start with, if I may, and I know you've managed to, as I say, to field this complete team of experts. So rather than to ask you to field the questions through to people and put them on the spot, I thought I'd do that. And so I'm going to start actually with additional courts and tribunal capacity, because in terms of buildings and Nightingale courts. Could I ask this? Will the court closure and sale programme cease? And I think Claire Barrett's the expert on this.
Thank you. So in response to that question, there are currently no plans to consult on court or tribunal closures, but I say that with a bit of a caveat, in that we are currently consulting on the future of Medway County and Family Court. This itself is based upon a necessity to vacate the building, so it's driven, if you like, by events which are beyond our control, the fact we cannot remain in that premises. So we are focused on looking at how best to increase the capacity of the court and tribunal estate on a temporary basis, which is the whole purpose of what we call ACTC, or commonly Nightingale courts, and in direct response, as you say, to the challenges presented by COVID-19. So through the ACTC programme, we are both acquiring additional physical space, which we may well come on to, but we're also looking at how we can supplement and expand use of our existing estates. We're thinking about things like screening within courtrooms. We're thinking about where we can take opportunities to increase footprint through things like modular builds at site. So it's not all new sites coming on stream, but that's certainly, that Nightingale component is certainly part of it. So to summarise, there are currently no further plans to consult on closures.
So Claire, you've covered a couple of things there. One is Nightingale courts. I'm going to come back to that in a minute. But you talk about there were a lot of questions that came in dealing with specific court rooms or court centres across jurisdictions. and if I could summarize them, it's what are you doing to make full use of the court estate? And you talk about thinking about screens and thinking about modular units. Can you just tell us what you really mean in words that people who may not be working for Hmcts will readily understand?
Sure. So there are a number of levers to expand our footprint, our estate footprint. One of the key things that we're actively pursuing at the moment is installing perspex screens into courtrooms so that jurors can sit more closely together with public health protections in place. So this will reduce the size of the rooms needed to hold jury trials and enable more jury trials to take place within existing courtroom spaces. To give you an idea of size and scale and pace on that piece alone, we've currently identified 59 buildings where this option and opportunity would have benefit. That's 176 courtrooms in total. Now that isn't to say we're going to do an installation in all 176. Some may be more suitable than others for the screening package, and some will be much more regular, and some we will have to think about how we bespoke, because all courtrooms, as you know, are quite different, and our building estate is quite different. But there, if you like, is an exciting lever that we're using to expand our existing courtroom capacity, and that's being rolled out now. We have 2 sites that are actively using the screening solution, and over the next week, 10 days, 14 days, that will continue. Coming on to another lever which is really key and helping us to increase our estate capacity is what we're calling modular temporary builds, or if you like, the porter cabin type solution. There are 30 sites which have currently been identified as benefiting from the modular building solution, and this will help to either directly free up Crown Court rooms, but mainly by taking the management of the jurors, so the jury, out of the substantive court building into a space which is where social distancing can be maintained, and they can navigate around that space, freeing up more opportunity for within our substantive building, so that we can safely allow people to navigate and get the numbers up, basically, so that we can optimise our courtroom usage. So modular builds is another really exciting rollout that we're doing at the moment. You will start to see modular builds appearing at sites from next week, and that will continue over the next 3 to 4 week period. So again, a very swift rollout of something which helps us with capacity. And then the final part of the jigsaw that we're working to, and it's by no means that we're not looking at other opportunities, there's certainly others that are coming onto stream all the time, but that is the actual Nightingale Courts piece. So this is identifying additional sites which can be used as hearing space to expand our current footprint on a temporary basis. There are 10 sites that were identified and announced publicly on the 19th of July. 2 of those sites are currently up and running, and the other 8 will become live throughout the month of August. And we are working towards identifying other sites, and that will progress onward as well. So some really exciting, swift developments that we're bringing through. We're looking at much more, we're also looking at other opportunities, as I say, within court spaces where we can reduce the size of furniture, for instance, which may enable people to navigate around a building better, or reduce the impact of 1 metre plus or going out to 2 metre distancing. So there's lots of opportunities that we're considering. We're trying to be innovative and think thoughtfully about how we can work at pace and work together.
Well, thank you for that. And one of the things that I know that you're aware of as a sort of common thread amongst many of the questions that was asked, why is this necessary when a lot of the courtrooms are empty? And I don't know who'd like to to deal with that sort of head on? I don't know whether it's Claire or Susan even.
Can I just say something about that? So this goes back to what I was saying at the beginning, which is, I mean, this is the fundamental challenge of this particular crisis, which is we can't use all our courtrooms because we can't fit people in them 2 meters apart. So we just have some courtrooms that are too small. And then we have some court buildings where, in theory, the rooms themselves are big enough, but if we use all of the rooms, then we have a massive problem with the number of people that we have in the common areas of the court. And so the first time we went round, we asked every manager in every court to say, okay, which rooms can you bring into use? And they went round and did this assessment. And we've then been, particularly in the Magistrates Court, we've been tracking the court to say, okay, of those rooms you think are safe to use, what proportion of them are you now using? Because we'd seen the work really fall off as we went through that period. We were really only doing the most essential things because we were, you've got to remember how high people's anxiety levels were, Amanda, and you were lobbying me to stop work. The secret barrister was writing articles saying stop all Crown Court trials until September, right? So the context was of people saying do less, why are you doing all this stuff? So the work level came really far down, and we've then been really trying to kind of grow that back up again because we know we need, there are people waiting who need their cases heard. And what we've then done is say, okay, we've now learnt a whole load about what we can do at 2 meters, and we went round and we've asked people to assess again, and that's shown us there are more rooms we think we can bring into use because people have learned how to move people around the public areas more safely. We've got a whole load of mitigations then for 1 meter plus, and so we're in the process, and you're completely right, and those who observe it are completely right. You will still walk around court buildings now today and see rooms not in use. Some of them we cannot bring into use safely. Some of them we can bring into use safely, and we are in the process of doing that day by day and week by week as fast as we can. So it's not, I'm not going to claim to anybody that we've got every room in use across the estate that we possibly can right now. What we have is an increasing number. So every day there are more rooms in use across the estate. Every day we're trying to stretch the number that we think we can safely use. We're trying to put those things in place, and we're trying to get the cases listed in a safe way so that we can hear them and grow it. And you will just see that keep growing and growing and growing. And I've just seen a question up that says you didn't have all rooms in use before this. That's true. So last year we had a different problem, which is that we had rooms, we had judges, but we did not have sitting days. So the sitting day is a bizarre thing. It is the unit of currency that gets used for us, and it's not set by us. So what happens is effectively there's a negotiation at the beginning of every financial year between the Treasury, the Ministry of Justice, the judges, and sort of Hmcts board, where we say, right, this is how much we think we need in order to run Hmcts well this year. And then there's a kind of horse trade, and everybody goes through this process, and then we get allocated a budget. But we don't just get allocated a budget, we also get allocated a number of sitting days. And particularly in the criminal court, so in other jurisdictions, we're given some freedom to move days around. So if we find we've got a bit more than we need in civil, but a bit less than we need in family, then we can flip them over, and nobody's too worried about it. In the criminal court, the MOJ sets us an envelope for sitting days, and we can't move it. So even if I have the money and the judges in the rooms, I can only sit the number of sitting days that have been allocated. And that is because the MOJ is trying to plan across the whole of the criminal justice system, and they need to know the implications for other parts of the system when they set those days. And last year, so after 2 years where we'd had sitting day allocations which allowed us to reduce the number of outstanding cases, to reduce waiting times, it was a tougher negotiation, and we ended up with a lower number of days. We said we want to be able to come back in year because we think that the caseload might go up, as indeed it did in 1920. And the Lord Chancellor then allocated more sitting days during the course of the year, but it was still very tight. And I think it would be, again, I'm not going to kind of deceive him, but we did not have enough sitting days to keep pace with the number of cases coming into the system. But we did not have the flexibility to sit more than the days we were allocated. And so last year, that is why you would have seen rooms that weren't in use. What we've done, so before COVID, we were then doing the conversations about sitting days for this year. And this Lord Chancellor had said, right, I want to allocate enough sitting days that we can be in a better position this year and recover. he set a minimum level of 87,000, but actually we were in negotiation about a higher level than that. So he'd set that level in January, February, so that we could list more aggressively into this year, because the further ahead we know, the better we can plan and put that in. And he was all set to set a significantly higher level for Crown Court sitting days. And then COVID hit us, and it became clear really early on that that wasn't going to be, we weren't going to be in the game of counting sitting days. We were going to be in the game of trying to do as much as we could possibly do under these very difficult circumstances. And so both the Lord Chancellor and the Lord Chief have agreed together that sitting days just won't be a constraint this year. So if we can do the work, we will do the work.
Can I just ask a final question perhaps on this for the moment in relation to Nightingale courts? Will tribunals be included in Nightingale courts, Claire?
Yes. Do you want me to say more than that? What we're doing on the Nightingale courts is looking at the places where space is the constraint. So we've got again, it's a bit different across different jurisdictions. So again, crudely, if you look at the family court, the biggest constraint we've had in family court long time before the pandemic has been judicial capacity, because it takes a lot longer to train a judge than it does for the family caseload to increase. And when we look at the position in some jurisdictions, including in family, if we continue to use video and audio hearings at roughly the rate we're currently using them, we run out of judges before we run out of space. And so there's less need for Nightingale courts or for extended hours in a jurisdiction like family. In tribunals, again, it varies by jurisdiction. So we've seen a big drop in the social security caseload, and we've actually been reducing the backlog in social security. We've not been hearing cases at normal levels, but they've been way below normal receipts. And so we've actually been recovering the position, and the same is true in immigration and asylum. We've been pretty much keeping pace in mental health and SEN, although the receipts have been relatively high because we flipped those to work virtually, and it's working pretty well. The challenging tribunal for us is the employment tribunal, where again we had some challenges before this, but also we've seen very high levels of receipts all the way through the crisis, and we expect those to continue to be high and perhaps even to get higher because of the consequences of the pandemic for people and jobs. And in the tribunals where we can see that we're space constrained and it's going to be difficult for us to sit things, yeah, we're looking at what we can do through Nightingale courts, and we've got tribunal space in some of those already announced.
Thank you very much. Okay, so let's move on to civil, and I think Simon's going to help with that. Can you help us with in ordinary civil trials where personal appearance is needed? At the moment, they seem to be being adjourned. Why are the court officers waiting until less than 48 hours beforehand to notify parties of adjournments? Can you help with that? You are on mute at the moment.
Thank you, Amanda. Yes, there will be different reasons for why that's happening. Some of that will be down to the judicial resources available to do that and the staff resources. We've introduced triaging now of all cases before they're adjourned. So that is a more resource-intensive procedure than we had before. What we are trying to move to is doing that triaging 2 weeks in advance of a case being heard. So we're going through the list 2 weeks ahead of that happening, so that we can tell people whether their cases are going to be adjourned or whether we can deal with those cases remotely or by video. So we are trying to improve that situation and get to a position where we're doing this work 2 weeks in advance. But it has been a real challenge given the volume of cases in some of our lists.
Well, I think two of the issues that people come across most, perhaps in the county court, is perhaps a lack of staff. Historically, I don't know what the position is now, and a sort of the support for judges in terms of tech, and then tech. Can you give us I don't mind who deals with this as a tech question, or I don't know whether and Simon's wants to deal with that too.
I could probably deal with both questions. As you know, civil is a challenge anyway, because a lot of our work is still done on paper. So that's been a real challenge for us. So trying to work in a different way, and we're continually trying to develop that, but still a lot of work is done on paper. So that has to be moved around. and that's obviously put a lot of pressure on the civil staff, but we're looking to do that. In respect of tech, obviously, we've rolled out a lot of tech to the judiciary now, and as you know, we're rolling out CVP now to all the civil and family courts, and that will be our platform for dealing with remote hearings. And at the same time, we're looking through the money we've recently been given at about what tech, what screens, etc. we need to put in our courtrooms so that we can fully utilise CVP and video hearings in the future.
Thank you. Let's move on a bit more generally, CVP then, and remote hearings. Can someone provide details about planned increases in functionality of CVP, and secondly, training on CVP for civil practitioners?
There is going to be no further increases in the functionality of CVP. It is what it is now, and we've got the ability now to record. We have, in fact, done a considerable amount of training already for people. We've done awareness training for civil practitioners. We've done it for the Law Society, for the CCUA, family stakeholders. We're more than happy to do any more sessions if people would like them. And we're also developing online training materials for practitioners in all jurisdictions as well.
And for the judiciary?
We've done the same as well. We've run thousands and thousands of sessions for the judiciary and for the fee-paid judiciary as well. But again, we're more than happy to run more sessions if people feel there is a need for them.
Anne-Marie, do you want to come in at all on CVP and technology?
Thanks, Amanda. Yes, I'd echo everything that Simon has said. I would also say from the criminal jurisdiction, from the outset, we engaged with the legal professionals. We supplied guidance and awareness sessions and also CVP rooms out to circuit leaders, etc., so that they could have that engagement. They could look at CVP and almost play with it in their own time to understand how it worked and what it would be like for them. And we've continued to support with that, and the offer is still there if anybody needs any additional support. It's definitely been exceptionally well received. Some of the feedback that we've got has been really, really positive, and we're really glad that we've been able to support your colleagues as that has rolled out across the criminal jurisdiction.
Can I just say one thing on the functionality question? So, yeah. So Simon said there's no improvement to functionality, it is what it is. I think that's as far as the rollout. So we're rolling out into civil and family now. I think that someone asked a question on the chat, will be done by the end of August. And we're rolling out with it as exactly as it is. And the priority for the moment is to get it rolled out. I'll try and speak better. Well, to try and get it rolled out as it is. So at the moment, we're getting it spread out so everyone's got it. At the end of that, if there are things people can identify that would make it work significantly better, then as it were, the kind of hatch opens again on other improvements we can make to the functionality. So it's not a kind of, that's it forever. It's a kind of, at the moment, we've banked, this is enough functionality to get it rolled out, and the most important thing now is to roll it out in civil and family courts so everyone's got it and can start using it.
And have you found, generally from Hmcts perspective, that there's sufficient, broad bandwidth and all of the rest of it in courts, or is that a bit of a break on hearings being well conducted? I'm sure there are lots of people in this audience who have their own views on that, but you're on the platform and they aren't. So the moment,
I welcome other people's views on it. I mean, what we've relatively recently done a kind of upgrade of our Wi-Fi and broadband capacity. So we put the kind of better broadband into the civil and family courts, and then we've done another pass around the criminal courts in improving them. And we haven't, in general, found that the broadband capacity in court is a big problem for CVP. We've had two problems. We have sometimes found that Wi-Fi and broadband at the other end is a problem. That might be private individuals, or it might actually sometimes be police or prison endpoints, and we've been working with colleagues in police and prisons on that. And the second thing we had is we had a bad week, and I'm going to get the month wrong now, but I think we had a bad week in about June, Anne-Marie, is that right?
Yes.
Where we had a set of problems with the platform, and we had a few days where we lost some hearings because there were issues in the platform itself. It wasn't the court broadband, it was changes that the supplier had made to CVP that destabilised and they had to do that thing that IT people do, where they go back round and find the last stable version of it and revert, and then have another go at the changes to get them in stably. But those have been the kind of other people's broadband is a perennial. The week in June was a particular kind of peak of problem that we then had to kind of work through and come back round. Is that fair, Anne-Marie?
Yes, yeah, no, I think that's absolutely spot on. One of the biggest issues around that particular week was the concurrency of users, and I think it's because we moved so quickly with it and deployed it so fast and got them out there, which was fantastic, so that more courts could use it. But at that particular time in June, we hit 1,800 concurrent users in one session, which was astronomical for us. We've done some work with the supplier now, and we are currently at 4,000 concurrent users, and that will be at 8,000 by the end of August. That's the plan. We brought it forward. We didn't anticipate actually hitting that quite as soon as we did, so that's a testament to the users out there for it. Yeah, absolutely. The other thing that we've done as well is we've given guidance on how you can turn up and down your own settings, and we've done some user easy process guides to follow, and as Simon said, we're following that up with some generic guidance that can go out, and I think we're using the video format now so that everybody can utilise it, and that enables individuals to turn up or down their own settings to make sure that they're getting a stable signal throughout the hearing, and that's made quite a bit of difference as well.
One of the questions that's been posed, and it's rather a good moment to ask it, I think, is have you secured future funding to be able to improve and maintain the technology that you've got? Otherwise, we'll end up, being back at the beginning in a few years' time.
Yeah. So do you want me to say a couple of things about that? So to some extent, what we've done is pulled forward some things we were thinking about doing as part of the Hmcts reform programme, and the reform programme has built into the business case what are not very beautifully called disbenefits. So basically it says, if we do all of this change, then we will be able to make it ourselves more efficient in the following ways, but we will also cost more in the following areas. So we will need to spend more on tech, not just in a one-off hump through reform, but forever in order to keep this going. And those disbenefits assume that we need to keep all of the tech we're putting in, not just the video actually, but everything up to date, and that we have teams who can keep developing that and upgrading it and improving it over time, so that it's baked into the funding that we had. And effectively what this has done is it pulled forward some of our investment in both hardware and software, but it's not changed that position that kind of in steady state we need to be able to continuously invest in keeping things up to date.
And what about staff at your end? Training staff, making sure that they're on top of it all? Because just speaking personally, I'm not saying it was the staff members' fault at all, actually, but it took 45 minutes to get into a half-an-hour hearing slot in a case that I was involved in, and the hearing in fact took 3 hours, and a lot of that was to do with technology, and no doubt from the external, from the court's users' ends. But how do we make that more robust and therefore more efficient?
Yeah, so Anne-Marie, do you want to just talk a little bit about what we've done on staff training on CVP?
Yeah, absolutely, Susan, and Claire can jump in with the continuous improvement piece that we're looking at as well. So in terms of staff training, as you can appreciate, it was a very rapid deployment. We have continued to look at the training material that we've delivered to our staff, and we've amended it as we needed to. So in true agile fashion, it's been updated as we've gone along. Where we've found issues, we've developed things like technical issues guidance for our staff, quick users guidance that they can follow. I know there were some problems with people actually getting in, as you say, to hearings, being able to turn their cameras on, and I think we found something similar when we joined with this with Christina. If you've been on another solution before, sometimes your video camera is still attached to your Teams or to your Zoom, and you just have to reconnect, and then everything comes through correctly. We'll continue to do that, continue to support our staff, and as more staff come back into the courts now, rather than remote working. We'll continue to ensure that they're fully trained on everything as it moves forward. And we've also got that exercise that's ongoing at the moment to look at bringing in more staff to support video hearings. There's an exercise ongoing at the moment, and as part of that, we're doing a lot of training material to bring them up to speed, so that when they actually move into the court space, they can hit the ground running. And if Claire wants to add anything to that.
All I was going to say is I think we are alive to the fact that we need to refresh the training. It's a new product. People obviously don't use it every day of the week. So it's fair that we're going back in to support staff so that they are familiar with it, so they can basically pass on the learning to other users to hopefully make the connection a more smooth and satisfying experience for all that uses it.
Well, thank you. Thank you for that. So is there an HMCTS roadmap or strategy for uniformly dealing with hearings remotely in county courts and tribunals? That's a question that's been asked, and I know that there's a tension between two different things here. One is national and local, and the other is what's in your remit and what's in the judicial remit. But it's a question that's asked a lot, so it would be helpful to have some answers.
Yeah. So thank you, Amanda. I think there's a couple of things here. So there's something about what tech's being used, and increasingly we are trying to move towards using CVP and a kind of cousin of CVP that you might hear referred to as full video hearings, or in a blow to the past, VHS, the Video Hearing Service, which is being used in some tribunals and it's the same platform as CVP, but it's got a bit more functionality that's particularly suitable for doing wholly video hearings, and the tribunals have kind of early adopted that, particularly in tax, and we're going to roll it out in property shortly as well. So what I think I saw a version of this question which is partly about kind of there's lots of different platforms being used. In terms of the kind of approach to what's suitable to do by video and what's suitable to be done in person, that fundamentally remains a judicial decision, and there are some slight differences of approach in different parts of the system to what people are seeing as appropriate to do using remote technology, and what they're seeing as more suitable for face-to-face. And that's something it's a judicial decision, but we continue to work with them on it and to make sure that we are feeding in learning and experience from doing this. So we've got some work going on to kind of capture people's experiences a lot, as well as the work that's been commissioned through the Judicial Office, through the Nuffield Family Observatory and elsewhere. We've got some, we're surveying people who've been involved in video hearings and so on. So we're trying to use that to feed in so that we can continue to kind of support those judgments about what's suitable for video and what's not.
And I don't know whether Gemma can come in relation to this on crime, on the use of these hearings in crime. You're on mute.
Yes, so it's a similar position in that obviously this is down to judicial discretion. The work that Anne-Marie and Claire and the team have done around supporting the processes and making it crystal clear how and so that any hearings that the judiciary decide is an appropriate one for video can move and be worked through as seamlessly and as efficiently as possible. Will continue to assist, but it is fundamentally a judicial decision on which of those hearings are suitable for video. I think it's fair to say we have gone a lot further in the COVID period than we anticipated previously, and we will continue to look to that, and how as that improves and as the efficiency improves and as the evaluation of that is completed, how that might be sustained going forward.
Yeah, and I don't think any of us want to, and again, the Lord Chief has said this very clearly, none of us are in the business of kind of going backwards as a result of this. We want to try and take the learning we've got and go forward. So my own view is we have found that there is a lot of work that is well done using video. It's not suitable for everything, and it suits some things better than others. But we as again, what I hear from practitioners is there's a lot of stuff where people are saying, well, we should just carry on doing this because it works. And we're keen to kind of pull that in and support that. So
let's move to extended operating hours. I see Jason's absented himself, at least from his photo for this. But I'm going to start actually with some general questions about. I think you may have already covered it, Susan. But at the moment, is it right to say that there aren't plans to extend the operating hours at this moment in courts that are either not criminal or the employment tribunal for the moment?
So for the moment, what we're focusing on is those places where the space is the biggest constraint, and that's most true in crime and in the employment tribunal, and that's right, that's where we're starting. We think that there will be some civil courts where, so in civil, the kind of balance of what we're constrained by is quite close at the moment. Again, this is very crude, but basically in Crown courts, even if we use, so again, I can see a couple of people in the chat saying you don't need to do this, just use all the courts you've already got. But when we model forward and look at how much work we've got to do, we run out of court buildings that are usable with social distancing. Even when we add all of those ones that are not in use at the moment, we run out of space before we run out of judges. So we have people who could hear cases, but we don't have the space to sit them in. And that's why we're concentrating on ways of increasing the space available to us. In family, we run out of judges way before we run out of space, unless something very surprising happens to the proportion of cases that are happening virtually. So if we stop doing any virtual work in family, we might run out of space before we run out of judges. In civil, it's much finer. So the moment we run out of space and the moment we run out of judges comes much closer together. And that means we think there may be some parts of the country, and we saw this before COVID. So typically in the civil courts pre-COVID, space wasn't the issue, but in some particular areas it was. So we know we've got some bits of the country where we're more space constrained than the county court. And so we're not ruling out using some extended hours in those places where we're space constrained, but it would be locally determined, locally driven and based on need. So we don't have a sort of massive, we've got a much wider need in crime and in employment tribunals than we do in civil. And as I say, in family, we think it would be the answer to the wrong question. Does that help?
There's a specific question about, are you planning to extend opening hours to the business and property courts?
I don't think that we are particularly space constrained in the business and property courts, and they've been getting through the work at quite a high rate. So at the moment, no.
And it's worth, Amanda, just adding to that the business and property court and a number of courts allied with the Royal Courts of Justice and the Rolls building were not within the scope of the working group, particularly around civil or indeed any of the other working groups. So things like the business and property court haven't been considered.
But I don't think we would, in a sense, we'd have been making sure they were being considered if we thought that
there was a need. Yes.
Yeah. So
Jason, I'm going to you I think have been the volunteer for extended operating hours, and so you've got the easy questions.
You volunteered, Amanda. Anyway, go on.
How will women and anyone with caring responsibilities be able to become judges when their prior careers as barristers and solicitors are no longer compatible with having children as a result of extended operating hours?
Okay, obviously there are so many layers to that as a question. I come at this and think, is what is currently being proposed, would it lead to that outcome? And with what's currently being proposed, we don't think so. I think also within the context of the proposals which the working groups have developed, they've been conscious of putting in place provisions which enable practitioners, which enable those who are representing defendants to put representations to the court where they're placed into a court list which is impractical, and some of those reasons will relate to childcare. I know some of these issues are really prevalent amongst the bar, but what we're talking about is an emergency measure which will run for a period of time. So whether that will have a long-term impact on diversity amongst the judiciary, I would suggest not, but I know that this is an incredibly sensitive area.
And what, let's talk a bit more directly then about what about working at weekends, sitting at weekends? Is that going to happen in the Crown Courts in the immediate future?
So the proposals which the working group have developed thus far are concentrated on Monday to Friday. So they've developed what's called the blended solution, which is in essence the blended solution as a way of piloting the approach in two courts. One court would run a morning session between 9 o'clock and 1 o'clock. There'd be a 60-minute turnaround.
Jason, do you want to just flip up the slide?
Yes. Yeah. Sorry.
That's all right. It's just it'll be easier for people if they can see it while you're talking about it, I think.
Can this be seen?
Yes. Thank you very much.
I'll just move so I can see it. There you go. So this is the proposed model that will be adopted in a small number of Crown Courts. We can see here it will have a morning sitting which takes place between 9 o'clock and 1 o'clock, and we'll have a 30-minute break in it. There'll then be a 60-minute handover, whilst obviously there's a cleaning of the courtroom and a changeover of the various people who are involved in the next case. The next case will then run from 2 o'clock to 6 o'clock. There's been some initial criteria which has been developed about the types of cases that are suitable for either of those sessions. And then alongside that is a court which operates standard operating hours between 10 o'clock and 4:30. So what's being proposed is really a kind of blended model. There's the opportunity for the morning cases, for the afternoon cases, and then there's the standard hours court, which is there to deal with those cases as well, which are considered unsuitable to be able to place in either at the AM or PM trials.
And Jason, I think it's worth saying that if a Group A case overruns, it overruns into the following morning. So you don't run, nobody does morning and afternoon.
That's absolutely correct, yes. And there won't be any shifting of cases between the two lists on any given day, unless there are exceptional reasons which a judge looks at. But in the ordinary case of events, if a case needs to run over, it will run over into the same pattern, and cases won't be shifted between the two patterns.
Thank you. So I have a question actually for Helen, which is, I don't know whether people still need that PowerPoint up. It's going to go, by the way, into the Bar Council's message tomorrow, so you will be able to have that to hand. Thank you very much. So Helen, obviously a lot of, I don't know if you were able to see it, but a lot of words on that screen had the word listing. There were a lot of times that the word listing came up. And I don't know if you can just tell us a little bit about what you've been doing, because you've been very involved, I think, as well with the judges and trying to work out what would be a even vaguely viable form of extending the court usage. How is it envisaged that the cases will run? I mean, how much do you expect the judiciary, if listing is a judicial function, to, as it were, make sure that the right cases are going into the right list?
Okay, thanks, Amanda. So the first place that is going to be our first early adopter is Liverpool, and we've circulated the document that the resident judge at Liverpool has developed specifically for this purpose. And what that talks about is the type of cases that would be selected and would be suitable, and also the process by which those cases will be listed, and that how representations can be made for the appropriateness of the case being listed in either the morning or the afternoon session, or if it's not suitable, the standard hours session. And so that's partly because we recognised, and it was said in the working group, and we've had conversations ourselves, Amanda, about the need for listing, whilst it is absolutely is a judicial function, the need for, in circumstances like this, where it is very sensitive, the list is very sensitive to the needs of all parties, there being more collaboration than would otherwise happen in advance. And the protocol that's been written by Liverpool has been shared with all of the regions and indeed the circuit leaders. We are not, and we cannot mandate that that protocol will be applied everywhere, but I know, for example, that in another circuit or another place where it's going to be tested, the same protocol is going to be applied. So I think it is, we have taken it as far as we can, and that's partly why on the slide that Jason shared, and we've put that on gov.uk as well, that's partly why we put some of the detail in there to say this is how it will work, but you will be listened to effectively if you're not able to list or to appear either in the morning or the afternoon session. I hope that answers the question.
So actually, sorry, just while you've been speaking, can I just add this, a question that ties in with it, is if you cannot be in the morning or the afternoon list because you've got a COVID related issue as the advocate, how long is your case likely to be put back in the ordinary list, as it were? And isn't it likely then that the solicitor or the client might say, well, you know what, I want to go ahead? And that is where they get rid of the barrister or the solicitor advocate, whoever it is, who can't attend. And that's, it's suggested in the question, is where the discrimination arises. So is that something that Hmcts and the group that you're very involved with, His Honour Judge Minari, is that something that's been raised? Is that something that's been taken into account?
It is, and I think the Liverpool note sort of sets this out clearly, that it is something that will be taken into account. And I think this is why we're saying that the AM/PM model cannot be applied anywhere yet where there is not also simultaneously a standard hours court. So we're not implementing it or testing it anywhere where there is not also the provision for cases to be listed in the normal way, precisely for this reason. And I think the note that was written by Liverpool, and I'm sorry to sort of reference that so many times, but it does make clear that it will be listened to, and that a minimum of 2 weeks in advance the list will be developed, and then there will be the opportunity to make representations of that. So I understand the point that you're making, because the way that we've operated the working group and we've taken those points on board, I think it would be highly unusual for it to operate in one of our early adopters without that kind of representation being listened to. So I understand the point that's being made and the concern. We hope that what we've put in place mitigates against that risk.
So let's just sort of move slightly away from that. What steps are being taken to ensure that defence advocates can take instructions via CVP from clients? Because honestly, if there's one thing that's going to put the kibosh on this, it's not people not being able to take instructions, either because the client doesn't arrive at court in sufficient time, or because there isn't sufficient video or conferencing facilities, either in person, but importantly CVP. I think Claire and Gemma are both getting their buzzers ready.
Well, can I just suggest that Helen does this in respect to EOH, and then Claire and Gemma moves on, because there's a wider issue, I think. I mean, the EOH is focused on substantive jury trial, where we would in general expect that the defendant will be present. So the CVP issue is a bit less acute for that. But I think Claire and Gemma might be good to pick up on the wider point around getting access to clients in custody, in particular for consultation through CVP. So Helen, do you want to just do how we make sure PECs get people there on time?
Yeah.
Just before you do that, may I just come back and say, of course, the trouble is that with criminal cases, you've got to have the instructions, and if your client's in custody, you can't get them in the first place. So it does actually have an impact, I think, on whether a trial is ready to be heard.
Yes, but there's two distinct things. There's what you need to do that morning before the case starts and what you need to have done beforehand.
Yeah. And
So
can you deal with that, Helen?
And
yes.
the bit that's before the morning doesn't matter what time the case is starting. See what I mean? Yeah.
So PECs are part of our working group, and we've been speaking to them from the beginning about, you know, frankly, it wouldn't matter if we open the doors to the court, if it would make no difference if we open the doors to the court earlier if PECs can't present the defendants any earlier. So it absolutely is the case that we've made it clear that has to happen, and they were involved in our detailed desktop exercise where we went through hour by hour right from the point at which the prisoner would need to be unlocked and the travel time, and that's why they're involved in that, for that precise reason. I'll hand over to Claire in a second, but this dependency on needing to get access to clients in custody in advance is very well understood as a challenge, and HMPPS have been doing a lot of work over the last few weeks to improve and increase their capacity. I wonder if Claire, this would be a good point for you to explain that and link it to the CVP point.
Yeah, absolutely. Thanks, Helen. I mean, there are two elements here, as Susan identified. There's the on-the-day court process, and then obviously the legal consultation visits. So if I start with the legal consultation visits, as Helen's identified, prisons have made a huge capital investment to increase their network capacity so they can actually have more legal consultation visits held using their equivalent of the CVP system. The latest I've heard is they're actually increasing their capacity up to 50%, so it will go a long way to supporting advocates being able to see their client in advance of the court hearings, and therefore making those hearings effective. The on-the-day process includes booking of both a pre and a post-consultation visit. So again, having access to the client before and after the hearing. We have an initial step that's been included, which means that counsel's details need to be provided to the prisons the day before the hearing to meet the prison security requirements. So effectively, we were looking at that, and it is allowing hearings to take place as long as we can get those details to the prisons in advance. We've also been told as well that face-to-face visits will be due to recommence quite soon, but CVP options will still be available for consultation to take place remotely. So there'll be a dual pathway to seeing your clients in the future.
I mean, I think a lot of people's experiences that there's a bit of a blockage with getting CVP consultations with people in custody, and that's obviously an issue.
I can definitely say we are aware of that, yes, and that obviously has an impact on the courts, because clearly that means we're having ineffective hearings, which is not what we want, which is why prisons have committed to increasing their capacity to hopefully alleviate some of those challenges that are currently being faced.
The reality of this is that the prisons are being asked to do video consultation at a scale way beyond anything that they were expecting. They've put some more capacity in, but it's slow because they need fixed endpoints, and they've also got to think about how they get the prisoners from cells to those endpoints, and we're doing a few things on that with the prisons. So they've got a program for putting more capacity into some of the prisons, and we've been working with them on where the pinch points are. So again, if people want to put in the chat, or elsewhere, and Amanda, we've talked about this before, we're going to, you know, if you wanted us to really target 3 or 4 or 5 places where it would make the most difference, because we'll do as much as we can, but it helps us to prioritise in the right places. I'm also trying to push with prison service colleagues on whether they can make more use of some of the technology that they've put in place for family visits. Now, the challenge with that is that family visits are monitored, and of course we can't have somebody listening in to legally privileged conversations, but I'm wondering whether there are some either technological or actually rather more basic, just not listening ways around that, that would enable quite a lot of kit that got put in to allow prisoners to have family visits to be used a bit more widely, and that's also being looked at. And as Claire says, when physical visits start again, that has 2 consequences. Obviously it means you can go and have a physical visit, but it also means there'll be more of the video capacity available. And then the other thing we've been doing is looking at whether we can liberate appropriately some of the slots that are restricted to the court or others for consultation. We know it's a challenge.
Oh, sorry.
I was just going to say, we know it's a challenge.
Rebecca, you've been sitting there patiently. From a family angle, how would you say HMCTS has managed through COVID-19?
And I think it's a real testament to my colleagues working in courts, how they've managed to maintain the hearings throughout the pandemic. We've sat, as many sitting days as we have in previous months during the pandemic. But what has happened is that the number of disposals has fallen. So we're looking at ways to increase that and exploring other methods such as triaging cases so that we use CAFCAS resources where they're really necessary.
And as far, I mean, you're right that they seem to really get on top of technology very quickly, and we know that they had all sorts of different platforms they were using, and there was a real drive to get cases through. But what I think practitioners are finding now, and it's a listing issue, but it is to do with technology, is that cases are not being sympathetically listed. Now, obviously, there is an issue in one sense about, when I say sympathetically listed, but you know what I mean in relation to the extended operating hours. I mean, is there, are you aware, is Hmcts aware of the fact that during COVID-19, many people haven't been able to progress their practices, which means actually that many members of the public are not getting in family the representative that they originally chose or had as their advocate. Is there anything that Hmcts are able to do in relation to that, or do you say that's all down to the judges?
Well, the listing is a judicial function, and we work very closely with the judges to facilitate hearings by whichever method is going to work best. We are aware of the number of lay unrepresented parties in family, which does make it more complicated. And we're making really strenuous efforts to make sure that we have their contact details, and that if they have difficulties joining a hearing, we know about it at the earliest opportunity and can make suitable arrangements for them.
I think, I mean, there's on that specific point about, so there's both the LIPS point, and I think the point you were raising, Amanda, was about people being represented by someone other than the advocate they'd initially chosen, because perhaps a listing decision's been made that means the original advocate can't attend. And I mean, this is
for a COVID-19 related reason, such as childcare or.
So I think this is one of those things where in a sense, it's an intensification of a challenge we've always had across the system, which is that the judges in making those listing decisions have got to balance lots of different competing interests. And I think particularly in family at the moment, the judges are really trying to make sure that the cases are getting heard because of the salience of them for everybody involved. And it won't always be possible to make that work for everybody. And so there are trade-offs and choices. I mean, one of the things that I'd be quite happy to do, which I think would be a reasonable thing for Hmcts to do, because again, they're judicial decisions, but of course we support those decisions, and we also try and make sure that we're kind of providing information to them. I'd be quite happy to have a look at whether we could, and I'm going to virtually guarantee that this is something that our legacy IT systems can't do, so I'm going to phrase this carefully, but we could have a look at seeing whether we could do a bit of a data capture to see whether we are seeing more people ending up represented by someone other than their original advocate than usual, because I mean, to some extent this happens a bit anyway, doesn't it? So we could have a bit of a look at that. Yeah,
I mean, I think the very stark position for many practitioners is that even in family, work volumes went down, certainly for some people anyway, and the very few occasions when they could get work, they suddenly discovered for a listing reason that was COVID related that they were unable to keep the case, and that of course had a bigger impact on them than it would have done had there not been this kind of very difficult position that everybody's in. Can we turn perhaps just I can see the time already, but can we turn to some very general ones? We've had quite a few questions about safety, about concern about going to court, someone who's shielding, the face masks are recommended but not required in public areas. Those sorts of questions are, can you, I don't know whether Susan, you're the best person to talk about it. I've heard you talk about it before.
Probably me with a bit of Claire. So there's a few things here. So the first thing is that we are assiduously following the Public Health England guidance at every turn. So we keep ourselves absolutely in a place where we know that our courts are safe according to Public Health England recommendations and definitions. And we've done a kind of extensive process of risk assessing every court, and you can ask for the risk assessment for any court that you visit, so you can see what's been done, what's in place, and what the kind of risk areas are for that individual building. We've then had a couple of ways where we've gone a little bit further. So masks is one of them. So the legislation on masks covers retail premises, but we had a look at that and thought, well, at the point where it's a good idea to start wearing a mask when you're in Sainsbury's, because although people are trying to keep socially distant, it's very hard to guarantee. We think it is sensible to similarly ask people to wear a mask in the public areas of the court. Now, we don't have the legislative cover that a shop has, but we aren't saying do it if you like. We are saying we are requiring people to wear masks in the public areas of our court buildings unless they have a reason not to, which is one. So we've set this out in the guidance. So there are people who may have health conditions which make wearing a mask dangerous for them, and there are a small number of other conditions. And if you're fulfilling one of those conditions, then of course you don't have to wear a mask because it might be safe for you. And that's the same as on the underground. They're actually the same conditions that are the exceptions to the legislation where it applies. But otherwise, we are asking people to wear masks in public areas. Inside the courtroom, it's more that we are saying that you may, but the judge may ask you to remove your mask to speak. But anytime anybody's asking you to remove a mask, you should be reliably 2 meters distant. And nobody should be asking you to remove a mask if you're not able to stay reliably 2 meters distant from the people around you. Because the masks are there for circumstances in which it's difficult to absolutely be sure that you can stay 2 meters away. And then the other thing I've seen come up in the Q&A is a question about ventilation. So again, we've done a lot of work with Public Health England on what the requirements are. And broadly speaking, if you have a ventilation system which meets the normal standards for workplaces, for office buildings, that is exchanging the air and expelling the waste air out. So we don't have systems in our buildings that circulate the air round and round the building. They effectively expel the waste air out and bring clean air in. And as long as there is such a system in place, or you have openable windows, PHE is saying that's fine from a COVID transmission point of view. And that's not the same as air conditioning. So I mean, obviously we will want there to be air conditioning when it's hot because it makes it much better. But air conditioning isn't making you safe from COVID. It's making you pleasantly cool. The thing that's making you safe from COVID is the ventilation system in the building rather than the AC. Claire, do you want to add anything on that? And that's something incidentally, that is something we're watching quite closely because some of the science on that is developing. But again, we just stick absolutely to the Public Health England guidance and we do exactly what it tells us we need to do. Claire, do you want to comment on that?
Yeah, just to reiterate that it's the Public Health England, Public Health Wales guidance.
Yes, of course. Thank you, Claire. PHW Wales.
Are they the same?
No.
And
from the point of view of things like ventilation, yes, they absolutely are. But 2 meters to 1 meter and mask wearing are subtly different in England and Wales.
Yeah, and just to confirm that the risk of transmission through air management systems is low, but to pick up what Susan just said, we're following the advice and changes, you know, as we progress through this crisis, changes have come out and we will monitor the advice and further monitor any changes and follow that advice as and when that comes out. So yeah, that's all I would add.
So I've got 3 questions I really want to get in before we finish from the previously asked ones. One is HMCTS prepared for a second wave of COVID-19?
Yes. I mean, as prepared as any of us are, I think. I mean, we have a plan now, which we've been working on internally, but also as part of a kind of cross-government cabinet office process. And that looks forward both at our kind of recovery planning, but also has a set of scenarios against which we plan. So there's a kind of, you know, there is a kind of moderate second wave scenario. There's a kind of apocalyptic, everything goes absolutely kind of not very well over the winter. And there's also a kind of, you know, happier path, things get better. And we're also planning against us seeing increasing numbers more kind of now, including the imposition of more local lockdowns in different places. And we've got plans that look at each of those scenarios and say what we will do. And they build on what we've learned at this stage. And just to give you sort of a bit of an overview, we've learned a lot about operating at 2 meters, about operating using audio and video, and we would not expect to kind of reduce our activity nearly as much in a second wave as we did in the first wave, because we've got ways of operating that are COVID secure that we think we can continue. But you'd likely to see more of a kind of further flip towards remote technology. Some of the things that we've done to go to 1 meter plus in some places, we've got contingency plans for going back out to 2 meters. And again, that's one of the reasons why we're not putting all our eggs in the basket of just going to 1 meter plus. And we are planning to go to 1 meter plus. We need some other things in the armoury as well, because in Leicester, for example, where the local lockdown was imposed, one of the things we did was wait on any proposition that we go to 1 meter plus and stick to 2 meter social distancing for everything that we were doing face to face in Leicester.
And so does that mean that the courts were not, I would say affected, but were they still doing the same volume as business before as they were before the lockdown, the local lockdown?
So in Leicester, we didn't reduce the amount of work we were doing. We just didn't move to 1 meter plus. So we didn't shut anything and we didn't take any work types out.
So the next thing that I wanted to ask is about sort of risk assessments and data and assumptions. Is there any data to show what percentage of judicial time is actually being used?
So we have different levels of data across different bits of the system, and we've got so that proportion of total judicial time is hard, particularly in civil and family, because so many judges sit across both jurisdictions. But what we have got is the proportion of the sitting days that were allocated at the beginning of the year. So notwithstanding that I've said those limits were lifted, that was a number that we had for kind of how much activity we were expecting to see in these months. So as Rebecca said, in the family courts, we've seen 98% of the sitting days that you would have expected to see used over this period used. So the judges have been sitting at something extremely close to the normal levels for those months. It's been significantly lower than that in civil, and that's partly because some of those judges have been doing the family work. And again, it's been lower than you would expect for the normal time of year in crime. And again, the sort of picture in tribunals depends a little bit on which tribunal you're looking at, and really tracks what I was saying earlier about where we've seen more and fewer receipts coming into the system and where we've been able to keep the work going virtually using audio and video.
So if I mean, is that material that's published? Because a lot of, I mean, apart from family civil, you're able, it sounds like, to track it.
We can certainly, as I say, we can count the sitting days being sat, and we can also look at fee paid bookings. So we didn't have a constraint on the use of fee paid, but we've really actively gone out and said use fee paid wherever you need them in order to get the volume of work, and we can see those fee paid bookings go up. I don't think we are publishing that at the moment, but I'm very happy to have a look at it. I mean, the MI shows the work being done, which is, and the two things march reasonably closely together. But I'm happy to talk to the Judicial Office about that.
And another sort of data question: where can we see the data on which Hmcts is planning to use and expand the court estate in order to clear the backlog?
So the data that says this is how much space we need in order to get through the work. I mean, that's basically the modelling that we've been sharing with some of the working groups, and I can show you some pieces of that now. I need to caveat this slightly. and say that the modelling evolves all the time. So we keep reassessing how many rooms we can bring into use, and we keep looking at what more we can do. And so it's not stable, it keeps changing. And that's not because it's wrong, it's because we want to keep making it better all the time. And a model is only ever an approximation. So this isn't currently published, but I'm happy to share some bits of it. We are looking at publishing a version, but it'll probably look subtly different from this when it comes out because of the fact that it changes all the time. So this is some of our modelling on magistrates' non-SJP cases. And this looks at disposal capacity according to the court numbers we assume under a set of different scenarios. So this first level is, if we assume that we have social distancing at 2 meters, what number of courtrooms can we bring into use, and what do we think our disposal capacity a week is? So that's about 5.5, bit north of 5,500, which is about 30% of our pre-COVID weekly average. If we go to social distancing at 1 metre and bring into use some extra AV rooms, then that takes our capacity up very significantly. So it approximately trebles it to 17,000. If we then add some additional hours, so that's this next row assumes we do that, and then we add some additional hours in the magistrates court. This is a fairly hefty chunk of additional hours. So this assumes extra 2.5 hours Monday to Friday and 2 sessions on Saturdays, but only in selected courts. That takes us up to about 21,500. And you can see this compares to the pre-COVID weekly average. And you can see some of these measures start to take us above 100%. But of course, we need to be above 100% because we want to not just to meet the number of cases coming in, but to reduce the backlog that's already grown. And these charts start to show our estimates of the forecast level coming in, and then what that means for the backlog falling and how long it will take to come down. And I've got similar charts, not identical, but similar for Crown and for the Magistrates Court. So again, I can share. Oh, no, I can't because my computer has decided to hate me. Hold on 1 second. We've got similar charts for Crown, for family, and for civil as well.
And is that, I mean, that's very, very helpful for people who are not involved in the sort of high level decisions and groups that I am actually quite privileged to sit on. But is it available to people more generally, or is there any intention that it should be? So
yeah,
people can understand what's going on?
That I've just shown you is not published at the moment. We do want to make it available as part of, so we've got some work going on to do more detail. So we said when we published our overarching plan, we do more detailed plans for crime and for civil, family and tribunals. And some of that headline analysis will be in there, but I would like to get to the point where we're publishing the modelling more regularly. So it's not, as I say, it changes all the time. We've had an extensive internal set of conversations about it. I'm a bit reluctant to put one point in time bit of modelling in the plan and say this is the plan, because the truth is we will keep iterating it and we'll keep developing. So what I'd rather do is say we will regularly publish the modelling that we are using and the latest version of that as part of the management information. So we've got this management information that we put out every month now, which is the thing that was linked to in that document that I showed at the beginning, and we can send that link round. It's not in there at the moment. What I'd like to do is add that modelling to the management information so that effectively you can just regularly look at what it's looking like, how it's changed since last time, what's going up, what's going down, and how it's shifting.
Well, Susan, that's absolutely brilliant. You've taken us to 5:30. You've offered us repeated modelling, and you've all answered all the questions that were thrown at you, which with a few that were done on this Q&A chat, but frankly, there were just so many more that were sent in. I think over 100 questions were sent in. So I've tried to sort of collate them in bits and pieces of one to another. But honestly, all of you have been terrific at explaining what's going on, because I think one of the big problems that people suffer from is a lack of communication. And I know that communications are very difficult, partly when they're not your own, but partly when you're liaising with so many different groups who all have their own view of communications. But from my perspective, it's extremely helpful to know what's going on and what's being planned. So I think we can keep the questions that were on the Q&A. I think that's possible. And we will, if there are any that need answering, I hope that you'll be able in perhaps the next week or so to address them if you can. And if you can't, if you filter them back through us, we'll do our best to direct them in the right way. But if I may, on behalf of everybody in this remarkably quiet audience of over 75, thank you very much indeed for this afternoon. Great.
Thank you very much indeed for having us. And if it's useful for us to come back and do something like this kind of at regular intervals, not just through COVID, but hopefully, I hope there will be life beyond COVID, but hopefully beyond, we'd be really happy to do that. And thank you everybody for all the questions. It's very odd not being able to see people, but thank you. And Amanda, thank you for organising.
Thank you very much. Have a good evening, everybody. Thanks a lot.
Thank you.
Thanks.
Goodbye.
Bye.
Thank you.
Bye.
Bye.
Thank you.